Hi, I'm John Covert, Director in the Biotechnology and Chemical Practice Group at Sterne Kessler. As March 16th rapidly approaches, we wanted to briefly discuss a timely topic related to First-Inventor-to-File provisions of the America Invents Act, AIA for short. The First-Inventor-to-File provisions of AIA appear in Section 3 of the Act. Most AIA provisions will be codified in Title 35 of the U.S. Code, most notably the complete rewrite of Section 102, the section that indicates what constitutes prior art. Significantly, the effective date provision for First-Inventor-to-File, AIA Section 3N, will not be codified in Title 35. This effective date provision will impact patent law practitioners for years to come, so it is important to keep a copy of the Act on hand. Also significantly, thoughtful prosecution and claim presentation will allow a practitioner to exert some control over which Section 102 applies for examination of a particular patent application. And, to the contrary, the provisions will provide possible traps for both wary and unwary practitioners. Section 3N1 indicates that, except as otherwise provided in this section, the amendments in AIA Section 3 will take effect 18 months from the enactment of AIA, meaning these provisions take effect on March 16, 2013. The First-Inventor-to-File provisions shall apply to any application or patent issuing thereon that contains or contained at any time a claim to an invention that has an effective filing date that is on or after March 16, 2013, or to any application that has a domestic benefit claim to a patent or application that contains or contained at any time such a claim. In other words, presentation of a single claim having an effective filing date on or after March 16, 2013 means that new AIA 102 applies for examination. The presentation of that single claim could be in the application under examination or in a parent application for which a benefit claim is made. Effective filing date for a claimed invention is defined by 35 U.S.C. 100 subsection I, and it means the actual filing date of the patent or application containing a claim to the invention, or the filing date of the earliest application for which the patent or application is entitled, as to such invention, to a foreign priority right under Section 119 or a domestic benefit claim under Section 120. Entitlement to foreign priority or domestic benefit requires that the earlier application provide written description and enablement support for a particular claimed invention. Filing a new non-provisional application or a continuation or divisional application of an existing application prior to March 16, 2013 will avoid mixing of pre- and post-AIA invention dates and provide some certainty as to which prior art provisions will apply to your application. If there is a concern that written description or enablement could be questioned for any claim presented in a continuation or divisional application, consider filing the continuation or divisional prior to March 16th. There is another twist to the effective date provisions of AIA Section 3N. Section 3N2 indicates that the provisions of pre-AIA Sections 102G, 135, and 291 in Title 35 shall apply to each claim of an application or a patent issuing thereon, while the provisions of new AIA 102 apply at the same time, and that occurs in the following circumstances. If the application or patent contains or contained at any time a claim to an invention having an effective filing date that occurs before March 16, 2013, or a specific reference under Section 120, 121, or 365C to a patent or application that contains or at any time claimed such a domestic benefit claim to an earlier application with a claim effectively filed before March 16th. Essentially, this means that an application including claims with mixed effective filing dates, those before and on or after March 16th, will be subject not only to AIA prior art, but also be subject to both 102G prior art and interferences. And what this really means is that this subset of applications can be invalidated because of a prior invention by another in the United States, or become subject to an interference proceeding to determine who was the first to invent. All that in addition to having the new AIA 102 prior art apply. As March 16th approaches, review your portfolios with an eye to determining whether it makes sense to file any continuations or divisionals. Also, review newer applications and disclosures to determine whether examination under old 102 will provide potential benefits in terms of a smaller universe of prior art. For applications or disclosures that would benefit from liberal common ownership and create act provisions of the new 102, consider filing an application with claims having mixed effective filing dates. Thank you.